read you this. The citation, it's a High Court judgment. The citation is I.A. Bell Equipment Company, Namibia. I.A. Bell, B-A-L-L, Equipment Company, Namibia, Pty Limited, versus E.S. Smith Concrete Industries, C.C., case number I-1860 of 2014. 60 of 2014 is a judgment by Masuku, A.J., and it was delivered on 23 March 2015. I'll tell you now. In paragraph 29, I read, my attention was brought to the case of Nedbank Limited versus Lowe, where there was a delay by a legal practitioner in filing the notice of appeal in a labour dispute. At page 218, the court stated the following regarding the lateness in the filing of the appeal. The reason for the lateness, he said, was pressure of work, and he apologized. Now, although the apology seems to express good manners, it is not a basis for condemnation. The pressure of work in the life of a legal practitioner is nothing new. In A Barrister's History of the Bar by H.G. Hamilton, he quotes a letter which Cicero wrote to his brother in late August of the year 54 BC. When you get a letter from me in the hand of one of my secretaries, you can reckon that I didn't have a minute to spare. When you get one in my own, that I did have 1 minute. For let me tell you, I have never in my life been more inundated with briefs and trials, and in a heat wave at that, in the most oppressive of time of the year, but I must put up with it. The court concluded by saying the art of legal practice is, in the words of Cicero, to put up with pressure and to perform within the rules, not to ignore them. It seems to have become a fashion to disregard procedural stipulations and to rely on condemnation as an entitlement. Even worse, to equate an apology with condemnation. If legal practitioners are driven by professional egoism and or financial rapacity, that they neglect briefs, such practitioners and their clients will incur misfortune. So there you have it. I was busy or overworked, and I overlooked is not going to be enough. All right. So we've dealt with sanction hearings under Rule 53. You asked me before the break to tell you where I can find where you can find, not me, I can find it, but where you can find reference to when a practitioner may withdraw in a civil case. You can look at the practice directions. Practice direction 50 deals with period within which counsel may withdraw. I'm not going to go into it. You can read it in your own time. All right, so we're back at part 6. We dealt with sanctions. Remember costs and punitive cost awards. So even where you, obviously where the explanation is that someone had death or serious illness in the family or something akin to that and was left in the hands of a competent person who then didn't attend to it or whatever, you may not want to give a punitive cost order, although the plaintiff would be entitled to costs in such a circumstance, just normal party and party costs. That would be wasted costs. Alternatively, punitive cost orders where you want to punish a party, where you don't necessarily strike a defense, but you want to punish a party nonetheless for their less than perfect approach to the matter or less than diligent approach. Rule 45 sanctions for non-compliance in absence of defaulting party obtaining relief, relaxation, extension or condonation. Where a party has failed to comply with a rule, practice, direction or court order, any sanction for failure to comply imposed by the rule, practice, direction or court order has effect and consequences for such failure, and such effect and consequences follow unless the party in default applies for and is granted relaxation, extension of time or relief from sanction. Where a rule, practice, direction or court order requires a party to do something within a specified time or specifies the consequences of a failure to comply, the time for doing the act in question may not be extended by agreement between the parties. So, where a time period has been set either by court order or by the rules, the parties between themselves cannot agree that that period be extended. Of course, if you want to apply for an extension of time or a relaxation of the time period or the rule, then you need to apply by way of interlocutory order, which means that you will have to engage your opponent in terms of Rule 32, Sub-Rule 9. But nevertheless, and we'll speak about that when we deal with interlocutory applications in a moment. But nevertheless, you will be obliged to seek an order from the court extending the time period or relaxing the rule. The parties cannot agree to that amongst themselves. The court must order that. It will help if the parties are in agreement that a particular time period needs to be extended. Then, where a party fails to deliver a pleading within the time stated in the case plan order or within any extended time allowed by the managing judge, that party is in default of filing such pleading and is by that very fact barred. So you can't then, if you then proceed to file a plea nonetheless or a pleading, then it will be an irregular proceeding because you are barred. Then Rule 55, upliftment of bar, extension of time, relaxation or condonation. The court or the managing judge may, on application, on notice to every party, and on good cause shown, make an order extending or shortening a time period prescribed by these rules, or by an order of court for doing an act or taking a step in connection with proceedings of any nature whatsoever, on such terms as the court or managing judge considers suitable or appropriate. So a party is required to make a physical application and to show good cause. And we'll deal with what those requirements are in a moment when we deal with condonation applications. Then Rule 56, relief from sanctions or adverse consequences. You asked earlier, once the court has made an order for granting a sanction, what can a party do? What relief is open to a party against whom such sanctions has been imposed? So Rule 56 says, on application for relief from a sanction imposed or an adverse consequence arising from a failure to comply with a rule, practice, direction or court order, the court will consider all the circumstances, including whether the application for relief has been made promptly, whether the failure to comply is intentional, whether there is sufficient explanation for the failure, the extent to which the party in default has complied with other rules, practice, directions, or court orders. So in this case, your past will be held against you. Whether the failure to comply is caused by the party or by his or her legal practitioner. Whether the trial date or the likely trial date can still be met if the relief is granted. The effect which the failure to comply has or is likely to have on each party, and the effect which the granting of relief would have on each party and the interest of the administration of justice. So, if I apply for, there's a claim against my client for 50 million Namibian dollars. I act for the defendant. I misdiarized the file to the extent that I missed an appearance, which obviously is an oversight on my part, and it happens. I filed an affidavit explaining this, saying it's not I was instructed to properly attend to the matter. I had the intention to, but I made a bona fide mistake by misdiarising this matter, and so it didn't come to my attention, and I apologize, and I meant no disrespect by it, and please can you reverse the striking of my client's defense, because it will be a $50 million claim against my client, which will financially ruin my client, and at the same time the doors are closed to the defendant due to an oversight on my part. And I say the trial is only set to commence in 4 months' time, so we still have time to finish the pre-trial order, and we'll still meet the trial dates. You will be more likely to grant the order because there's a full and frank explanation, and although it was an error, these things happen. People make mistakes. So misdiarising can happen, does happen often, especially where secretaries resign and new secretaries come in, because practitioners rely heavily. That's not to say they can hide behind their secretaries, but they rely heavily on the assistance by secretaries, and especially when one resigns and the other one takes over, you often find that there's a period of dismay, chaos in a practitioner's life. An application for relief must be supported by evidence, in other words, a full affidavit setting out good cause. The managing judge may, on good cause shown, condone a non-compliance with these rules, practice direction, or court order. So it really is a condonation that's granted. That takes care of sanctions. We'll be dealing with interlocutory motions for the rest of this day. Rule 32 is an important rule relating to interlocutory motions that you need to have regard to. We'll be looking at exceptions and irregular proceedings. We'll be looking at summary judgment. We'll be looking at postponement applications and postponements in general. And then we'll be looking at condonation and amendment of pleadings. So it's a lot, and there's a lot of principles relating to each of them. But I'm going to try and give you an overview of what they are all about and how it works. So, in terms of Rule 32.9, Rule 32 generally deals with interlocutory motions, and it guides how these motions are to be approached and adjudicated, etc., etc. Please read the entire rule. I'm going to make specific reference to Rule 32.9, 10, and 11. So, Rule 32.9 requires of a party who intends to bring an interlocutory motion to first engage his or her opponent to see whether an amicable resolution of the issue is possible, and so as to avoid unnecessary interlocutory skirmishes. The rule doesn't prescribe how this engagement should take place, but I can assure you that the requirement is that it should be bona fide, and that it should not just be mere lip service to the rule by saying, well, I'm engaging you, so what do you have to say about it? It really requires the parties to not necessarily always meet at a round table conference, but at the very least write to your opponent and say, I intend applying for this, that, or the other. This is the basis upon which I intend to do it. I propose that we can reach an amicable resolution of this by the following means. Please revert with your instructions. And then the opponent can say, you're quite right, I'm not going to oppose, or yes, I'm going to oppose, stuff you, I'm not going to agree to this. Okay, they won't really say stuff you, but that'll be, I suppose, what you can read into that. All right, so just because a party has agreed to the relief you may seek in terms of Rule 32.9, that a party has agreed in terms of Rule 32.9 to the relief that a litigant intends to seek by an interlocutory order, that's to say an amicable resolution was achieved, doesn't mean that it always alleviates the need for the actual application. Simply because, for instance, you may, if one looks at the list that we are going to be dealing with, an agreement under Rule 32.9 may alleviate the need to raise an exception or irregular proceeding, because the other party may concede and may amend or correct the irregular proceeding. It may alleviate the need for summary judgment because the party may concede to judgment being granted in their favor. But it certainly won't alleviate the need to bring an application for a postponement, for a condonation, or for the amendment of a pleading. It might actually alleviate the need to bring an actual application for the amendment of pleadings, but definitely not postponements and condonation. There you still need, and also relaxation in terms of Part 6 of the rules, you still need an order by the court. You see, so having your opponent's agreement in respect of those two, for instance, is helpful, but it won't open doors for you because you still need to convince the judge. There's no exhaustive list of interlocutory motions. If you can think it, you can probably bring it. So in our discussion here, you have heard a number of manners in which situations can present themselves where parties need to apply for interim relief. It happens often, and some of them are trite, like summary judgment, applications for condonation, exceptions. Those are run-of-the-mill, trite, not run-of-the-mill, but trite interlocutory applications that are well known. But you may need to apply for a further witness to be added to the witness list in the pre-trial, etc., etc. Those crop up from time to time, and it can have several different variations of how you can apply. You must be able to distinguish an interlocutory motion from a substantive application. And then the next question you may ask yourself, why is this distinction important? It's important simply because it has an effect on costs. It has an effect on appealability, to name but two. So there are a number of ways in which an and it also, a substantive application is dealt with differently under the rules, the procedure, as opposed to interlocutory motions. So it's important to know whether a particular application is interlocutory or substantive in nature. I suppose one can, as a point of departure, say generally, not always, but generally, where an application is dependent on some main relief being before court, being pending before court, it's probably safe to say that you're dealing with an interlocutory application. I think in the criminal court you would be referring to it as a trial within a trial. So it's an interlocutory, it's pending the main proceedings, you're dealing with an issue that crops up. Rule 3210 says that after you have engaged your opponent, in terms of Rule 32.9, you must file a report with the registrar before you launch your application, your interlocutory application. And in that report, you should say that what attempts were made in terms of Rule 32.9 to reach an amicable resolution and what the outcome was without disclosing, without prejudice exchanges. And then Rule 32.11 is also important, as I told you yesterday. It caps costs for interlocutory applications at 20,000 Namibian dollars. Remains within the discretion of the court, so the court can, in certain instances where it's a complex matter, both parties are equally represented by one or two instructed counsel, etc., etc., the court can deviate from that rule in order that the capping of Rule 32.11 would not apply. Exchange of pleadings. As I've said, it differs. You will have a founding affidavit, you will have an answering affidavit, sometimes also referred to as an opposing affidavit, and you will have a replying affidavit. So the party who launches the interlocutory application will file a notice of motion accompanied by a founding affidavit. Then your opponents will have the opportunity to file an answering or an opposing affidavit, and then you will, as the applicant in the interlocutory application, will again have the opportunity to file a replying affidavit. Please be mindful of the fact that there's authorities to suggest that legal practitioners should not easily depose to these founding affidavits on behalf of their clients, especially in cases where the matters fall within the particular knowledge of the client or where an explanation from the client is required. For instance, amendments at a late stage where bona fides is in issue. So these are really the issues that that you need to consider when it's exchange of pleadings. 3 sets of affidavits. You will deal with motion proceedings from tomorrow onwards, but know that there are these 3 sets of affidavits, and it's not different in interlocutory matters, and the magnitude of these affidavits are not different because it's an interlocutory. It depends on the nature and the complexity of the interlocutory matter. And judicial case management, as I said earlier, it's managed on an ad hoc basis, so there's no pre-trial or case management conference or case planning conference. The judge will give directions, as he or she is required to do in terms of the rules, as to when the matter will be set down, the exchange of pleadings, so when the parties will file their respective affidavits, when the matter will be set down, and whether or not the parties need to file heads of argument or not. Generally, in interlocutory applications, heads of arguments are not required, simply because it increases costs. If the matter is of such magnitude that the court thinks it would be of assistance to all parties that heads of argument are delivered, then the court will order that, and then a cost for that will be awarded. If the court does not order parties to file heads of argument in an interlocutory matter, then the party will not be entitled to seek costs, even if it's successful for having filed such heads of argument. That is interlocutory applications in general. I'm about to proceed to exceptions, which I want to try and finish exceptions and irregular proceedings before the lunch break, that it renders the matter urgent. I've never done that, but I can't see why you can't, although if you look at the rules relating to urgent applications, it suggests a substantive application, but I suppose you're really seeking condemnation for non-compliance with a number of rules. So it could be, I'm trying to think, when can an interlocutory application become urgent? I suppose it's fathomable that it could be. I haven't seen that, but it could certainly be, I suppose. No, if the court orders the parties to file heads of argument, the successful party would be entitled to recover his costs, which would include the heads of argument. Well, I mean, if there's no order as to costs, it follows that those costs are also excluded. So, because at the end of the day, if the court says there's no order, I'm not holding any party responsible for costs, then he's saying, but plaintiff, you pay defendants costs for the heads, and defendant, you pay the plaintiff's costs for the heads. The two will sort of cancel each other out. So it'll make no difference. So it's only where costs are awarded in favor of a particular party that would include heads of argument where the court has ordered. If the court makes no order as to costs, it's no order as to costs, irrespective of whether it had, because the court is certainly not going to pay the parties for their heads of argument. It's one party paying the other party, and that will only arise where the court makes a cost order against a particular party. Because if a party is successful, he or she is entitled to all their costs. So why should they now be penalized for a situation brought about by the court? Why should they be deprived of their costs if they were successful? That'll be the counter argument. But of course it's possible. Anything's possible. The approach, I believe, is that for some appeals you need leave, and for some you have an automatic right. Once you have an automatic right of appeal, the time period within which, I think it was the 21 days, within which you need to file your notice of appeal starts running from date of judgment. So if you then first proceeded to apply for, if you were of the view, and look, it's the area of appealability and the right of appeal in interlocutory motions is a very difficult field. It's a difficult field that's debated by senior practitioners who don't sometimes know which one is which. So what parties do is they say, well, I don't want to miss the bus on the 21 days. But I also don't want to be biffed because I also only have, I think, 15 days in terms of Rule 10. I'll check the court rule now. 15 days from date of judgment. That's also hanging. So you see what. So they have this double approach, and I understand that it's wrong. Strictly speaking, in terms of the rules, you need to decide. But parties often can't decide, and the courts sometimes differ in their approach. So I suppose a Supreme Court would not, where you are based on research and proper advice, you decide to first seek leave, and then it later transpires that you can appeal without leave, and the court says you then to go and file your notice of appeal and move for condemnation. And to say, well, I was under the impression that I needed leave, so I first filed an application for leave to appeal, but now, you know, whether that's going to be sufficient to obtain condemnation is questionable. So essentially what should happen is if the Supreme Court should not concern itself with whether or not an application for leave to appeal is pending. An appeal is filed, the Supreme Court deals with the appeal. If for that appeal leave was required and leave wasn't obtained, it should strike the appeal with costs. If then later an appeal is filed following a pending application for leave to appeal, which had then been finalized, or a petition or whatever, then that can be dealt with in that regard. So essentially, the Supreme Court shouldn't be concerning itself with what the parties are doing in the interim in the High Court. But they do, and therefore this is, if an appeal is filed, they deal with the appeal. Now, for all of them, you need to apply for directions. So in the case plan, you'll deal with summary judgment, you'll deal with irregular proceedings, you'll deal with exception. So there the court will striking out, the court will lay down the procedures if you want to make use of any of those in the case plan. So the court gives directions in the case plan. For all the other types of interlocutory applications, you would have to set the matter down for a status hearing. Say to the judge, I have brought or I'm going to bring this application. It's interlocutory. In terms of sub-rule 4, please give directions as to what must be exchanged, when and by whom, and when you will set the matter down and hear it. So that's what that's all about. Notice meaning you must give the other side at least 4 days notice, and notice is given by filing your notice of motion. Let's say, so you agree with me a summary judgment application is interlocutory in nature? Yes. So let's say summary judgment is granted. Does the defendant have an automatic right of appeal, or does it need leave? So what do you think? Do they need leave, a defendant against whom summary judgment, let's say summary judgment is for the entire claim. Do they need leave to appeal, or do they have an automatic right of appeal? When there's a final judgment, you would have an automatic right of appeal. Final judgment disposing of the matter. So you can't go back to the High Court. The High Court has given judgment. So you would have a right of appeal. Automatic right of appeal. Even though that order culminated from an interlocutory proceeding. The more difficult question, and the one that you are struggling with when reading that judgment, is, for instance, where an exception is granted. Where an exception is refused, you can't appeal even with leave. Where an exception is granted, say I raise an exception against the particulars of claim and for disclosing no cause of action. The plaintiff opposes that. The exception is upheld and the plaintiff is granted an opportunity to amend, but there's no way that the plaintiff can amend because it's stuck. Either it's that way or no way at all. Is that plaintiff deprived of the opportunity to appeal that decision? And my answer would be that with leave, such a party can appeal. What if the exception is not upheld? Then I can't appeal even if I obtain leave. I have no right. There's no right of appeal. So it depends on the circumstances of the matter. And yes, I think insofar as there has been, I'm not sure that the Westhuizen matter makes matters clearer. I just think that it narrows the field even more for a party to proceed to the Supreme Court. So I think don't fret if it's something that you struggle with. It's something that senior practitioners and even judges struggle with. It's not an easy branch of the law, appealability and appealability with leave, etc., etc. It's not easy. And it's something that has to be decided on the circumstances of each case. So you can have a hard and fast rule, but how are you going to apply that? Sometimes a very difficult question, which is why senior legal practitioners sometimes caution their clients to do both, file a notice of appeal and seek leave. And just because you seek leave doesn't mean that you're entitled to appeal even with leave. All right, so that deals with interlocutory applications in general. Exceptions. Can I just by show of hands see to whom of you is the word exceptions an entirely foreign concept? Who's never heard of exceptions? You all have heard of the term exceptions. I can accept that. So you know what an exception is? Anyone who's heard it but doesn't know, I just need to know in what depth I need to go into this. So by show of hands, who understands what an exception is and how it's used? So an exception, as I've said there, is a legal objection to a pleading. You will find reference to an exception in Rule 57 of the rules. An exception has one of two permutations. The one is an exception because a pleading is vague and embarrassing. And the other one is where it doesn't sustain a cause of action because it lacks averments necessary to sustain a cause of action, and therefore there is no cause of action or defense. I mean, an exception can be raised to particulars of claim or to a plea. You can even find exceptions in motion, so where a party proceeds by way of motion and he or she failed to make the necessary allegations in the founding affidavit to sustain a cause of action, the other party can use what is called an exception in motion. There is case law supporting that. It's not something that's often used, but it is certainly available in common law. It's not catered for in the rules, but it's also not outlawed in the rules. All right. So, it's important to decide when you want to accept. I'm not going to deal with the case management of exceptions because that is dealt with in the case plan. We've dealt with that. You know how it works. The judge will give directions, etc., etc. Now, with an exception, you must decide whether it is an exception where it's vague and embarrassing. In other words, you don't really know what is meant, and therefore you don't really know what you are expected to answer to it, how you are expected to answer to it. So it's vague and embarrassing for the reason that you don't know what case you are required to meet. So for instance, vague and embarrassing would be the party relies on an oral agreement and then attaches a written agreement. So which is it now? Is it the oral? What? That would be a vague and embarrassing exception. No cause of action is, for instance, in order to succeed with a claim for contractual damages, you would have to at least allege that there has been breach of the agreement. Because if there's no breach of the agreement, then surely damages shouldn't follow in your favor. Breach or repudiation or some other contractual. So if that's not there, or if you want to rely on contractual damages and you don't allege a contract, then I suppose you haven't made out a cause of action. It's important to decide which one of the two it is, because if it is the first sort, which is vague and embarrassing that I referred to, then you need to first file a notice in terms of Rule 57. I think it's Sub-Rule 1, which says that you need to file a notice. Sub-Rule 2, I'll check just a moment, that you need to file a notice on your opponent, the defect. If your opponent says, I don't care what you think, I stand by my particulars of claim or by my plea, then you proceed with the exception when the 10 days have expired. If, however, you feel that the exception is one where there's no cause of action as a result of the defect, then you proceed with an exception without giving notice. Be pleased to take notice that the first defendant hereby accepts to the plaintiff's amended particulars of claim, as it does not disclose a cause of action. So this is a straight exception. It's not preceded by a notice. And then we say the grounds upon which the defendant accepts to the plaintiff's particulars of claim are the following. This is, for instance, Stamp Duties Act. So it follows further the plaintiff's amended particulars of claim as a consequence do not disclose a cause of action and or do not contain averments necessary to sustain a cause of action against the first defendant. There's a second ground, third, fourth ground. So all the grounds are set out. Fifth ground, sixth ground. Oh, this is a long one. And wherefore the defendant then prays for the exception to be upheld with costs, the plaintiff's claim to be dismissed with costs. In the alternative to prayer B, that the plaintiff's particulars of claim, alternatively the annexures complained of, be struck out with costs. A further alternative would be that the plaintiff be ordered to amend, and then further alternative relief. So that's basically what an exception looks like in practice. So, vague and embarrassing, discloses no cause of action. So for the lesser serious one, give notice first, and then if the 10-day period passes, then you file your exception. Now the question, I suppose, becomes interesting when you look at Rule 32.9 and 10. Would it mean that you would be required to engage in terms of Rule 32.9 before you file the notice or after? Because the notice in itself, as far as I'm concerned, constitutes already engaging your opponent. But I think the idea is to actually engage your opponent off the record first in terms of Rule 32.9. So safe to say, engage Rule 32.9 first, and then you file your notice of exception or exception proper, whichever is the course that you decide on. The grounds of exception must be stated clearly and concisely. So you cannot say, because I think this person drafts horribly, and so if I read it, I don't understand what's going on there. That's not a ground for exception. You need to set out the grounds clearly and concisely. So for instance, and why I say that is everyone needs to know there's no answering affidavit filed or further pleadings filed based on the exception. When the exception is raised, the court takes the exception and the pleading that's accepted to, and only those two, nothing else. And the court makes a decision. So you're bound by what you set out in your grounds of exception. So you would say, for instance, plaintiff relies on a contract, a written contract, annexure A. Okay. In paragraph 4 of the particulars of claim, plaintiff alleges that it was a term of the contract that A, or let's do that. Let's say that Mr. A would pay Mr. B 1 million. Annexure A states in clause 6 that Mr. C will pay Mr. B NS 1 million. Accordingly, plaintiff's claim against Mr. B herein is for payment, against Mr. A herein. Isn't just Mr. A pay Mr. B, Mr. C will pay Mr. B. Okay. Plaintiff's claim against Mr. A herein is for payment of the NS 1 million, whereas the agreement relied upon places the payment obligation on Mr. C. Accordingly, lacks averments to sustain a cause of action. There is no claim. Because we'll accept that Mr. B is the plaintiff, yeah? He's the one who must be paid in terms of the agreement. And he now relies on this agreement but he's now suing Mr. A for specific performance, which is payment of the 1 million. So he's suing Mr. A. So Mr. A is the excipient. He's suing for 1 million, which is specific performance. Mr. A is saying in the exception, wait a minute, Mr. B, you rely on that agreement to claim specific performance of payment of 1 million, but agreement A says in fact that Mr. C will pay you. So you have no claim against me, you don't make, it could be that it was a further tacit or implied term or whatever of the agreement that in fact although the agreement says that Mr. C would pay, it was on behalf of Mr. A, which means that the payment obligation remains with A, but if that's not clear, doesn't sustain a cause of action. So maybe or susceptible to an exception. Grounds clearly set out. So if you read that, you can clearly see why Mr. A, as excipient, is accepting to the particulars of claim. You follow that, and that's what it should be. Okay, not in, I wrote quickly now, but they must be clear. A party is bound by the terms of the exception as set out in the exception that's filed. A pleading is vague and embarrassing where it contains sufficient allegations to sustain a cause of action or defense, but is defective or incomplete in some respect, which causes prejudice to the opposing party in the pleading process, i.e. it's capable of two possible meanings or contains contradictory allegations. So that's when that's how to establish when an exception is vague and embarrassing and not the other one which says doesn't disclose a cause of action. Where it is only vague and embarrassing, you will be afforded an opportunity to remove the cause of complaint, as I've stated earlier. Where there's been non-compliance with Rule 45, you'll remember Rule 45, for instance, says you need to make certain allegations if you're claiming for damages. If it's a written contract, you must attach it. You must say when, where, and how, etc., etc. The agreement was concluded. If a party didn't comply with that rule, you can elect. You can either make use of Rule 61, which is irregular proceedings, or you can make use of an exception. How you decide will often depend on the circumstances, or will depend on the circumstances of a matter. In order to succeed with a Rule 61 complaint, you need to show that there's prejudice, which is not a requirement for exceptions. For the purpose of deciding an exception, the court generally takes the facts alleged in the pleadings as correct. So, if you accept what will happen is the court will accept that what is in the pleading, what is alleged, that's not to mean that the court is making a factual finding on these issues. It is just for purposes of deciding the exception. It doesn't take away the onus from a plaintiff if the exception is unsuccessful to prove his or her case. It just says that while I'm deciding the exception, I'm going to accept that what you are telling me is actually correct. Unless it's blatant. So if someone alleges that Namibia became independent in 19... Ooh, that doesn't work. I thought this was going to help, but it isn't. Okay, no. Well, there goes that idea. See if I can get it clean, because it's... if someone alleges in a particulars of claim that Namibia became independent in 1976, the court will not take that fact, for instance. It's an extreme example, but you see how it's not true, it's not correct. So the court won't, in such instances, accept the correctness of an allegation in the pleading. So, you will have, say for instance, your particulars of claim, and then you will have an exception. The court, in deciding the exception, will look only at these two documents. Nothing else. No affidavits, no further pleadings, no further documents, only this and this. And in considering this, the court will say, I am going to accept the correctness of the facts alleged. I'm going to give you, Mr. Particulars of Claim, I'm going to give you the benefit of the doubt. That's not to say I've made a factual finding. If in the end the exception is not upheld, you must still proceed to trial in a normal cause and prove your claim. Okay. And in regard to the exception, the court will say you are bound to grounds set out in your exception, and only to the extent that these grounds are set out. So that's essentially what the court will say. I will look only at those two documents, and those are the considerations. My question is, let's say, for instance, there is a particulars of claim, and then there is a plea, And then there is an exception to the plea. Now, what does the court take into consideration? This or this? All three, because the plea obviously cannot stand on its own. More difficult issue. Let's see if I can. Oh, it just makes a bigger mess. Let me just wait for maintenance. Okay. So there's a particulars of claim. There's a plea. There's a counterclaim. And there's a plea to the counterclaim. And then there's an exception to the plea to the counterclaim. What does the court take into consideration? This or this? I follow your reasoning, and the problem you have is that a counterclaim is independent of the main claim. So even though it flows from the main claim or may have something in common with the main claim, you are required in your particulars of claim to make out a case in your particulars of counterclaim. You are required to make out a case much as you are required to make out a case as when you are instituting action. So, of course, the court would look only at those pleadings. You follow?
From the counterclaim.
Counterclaim, either the particulars of counterclaim or the plea to the counterclaim. No, I mean the parties will seek costs to follow the event. So if I'm opposing an exception, then I'll say that, thank you very much. I'll ask that the exception be dismissed with costs. You see, although I haven't brought an actual application, I will say, so in my address, I'd say, so my lord, in my respectful submission, the exception should be dismissed with costs. And the court, and costs will follow the event then. It's just when I say to, and costs usually follow the event. It's just where I say to the judge, I don't want a cost order. That the judge would not be hard pressed to actually make such an order then. Yeah, no, the other party would be entitled. Okay, so the main purpose of an exception that a claim does not disclose a cause of action is to avoid leading unnecessary evidence at the trial. So if, and perhaps this is a prudent time to refer you to some case law. Let me just find it. Essentially, what the authorities say is that exceptions is a handy tool to weed out unmeritorious claims. So it is useful because if there is an unmeritorious claim, the court can already sort that out at exception stage without it having to proceed to trial and wasting precious time and resources. You see, it forces parties to make sure that only claims that are meritorious should actually proceed to trial. The party raising the exception must satisfy the court that on all reasonable constructions of the pleading accepted to and on all possible evidence that may be led thereon, no defense or no cause of action is or can be disclosed. So it's a very wide test. The court would say, all right, I'm looking at this particulars of claim. I am going to consider any possible evidence that can be led, any possible reasonable inference that can be drawn, and on all reasonable constructions of that pleading. If on all those bases I still cannot find a cause of action, then the exception must succeed. It sounds like a very difficult test for an excipient, but I can assure you exceptions are upheld more often than not. Because once you get into a pleading, for instance, if you look at the example I gave you earlier, The agreement clearly says, it's a written agreement, it's got a non-variation clause. The agreement says that that C must pay B. Now B sues A. On no possible construction of that particulars of claim can you create a nexus between B and A. The obligation is C's. It might be that the agreement contains an inaccuracy, but then that must be sought by way of replication. The court cannot assume that, well, okay, if you allege at the trial that you're entitled to a rectification of the agreement, that you will simply get it. You need to seek that as a cause of action. You need to ask for that. And if you don't, then I must accept that the agreement is correct. So you will not even be allowed to lead evidence to say that it is in fact A who had to pay, because the parallel evidence will then prevent you from leading such evidence, because it is leading evidence that is attempting of surrounding circumstances or negotiations or whatever, which is with the aim to amend or vary or augment the terms of an agreement in which is in conflict with the express terms of that written agreement. Okay, I'm not here to teach you on the parallel evidence rule, but that's essentially just as an example on how these things may present themselves. Okay, so it's a wide test. All possible all reasonable constructions and all possible evidence that may be led on those constructions, still there is no cause of action or defense. A party is free to frame his exception in any way he chooses, but he is bound by the terms in which it is framed and by the issues raised therein. If the exception is upheld, the court will ordinarily accord the respondent an opportunity to file an amended pleading within a stated time, but it can result in the dismissal of a claim, striking of a plea, or a defense. An allegation which is in conflict with other allegations in a pleading may be objectionable either because it renders the pleading vague and embarrassing, or because it is irrelevant and should be struck out. So we've dealt with the procedure of how you raise an exception, on what basis you raise an exception, the two possibilities relating to raising an exception, and then what the court does. So the court accepts generally what is in the particulars of claim or the plea objected to is correct. The parties are not given an opportunity to file explanations or amplifications or further documents or affidavits. Just the document, the pleadings with the actual exception. The party who raises the exception is bound by the grounds set out in the exception and to the extent that they are so set out. So you can't amplify your exception in argument. The court will say that's not in your exception. Then the court will say on all reasonable constructions of this particulars of claim and all possible evidence that may be led on these reasonable constructions, including reasonable inferences that can be drawn from these reasonable constructions, there is still no cause of action or defense, and therefore the exception should be upheld. It can either be usually a plaintiff is or a person against whose pleading an exception is successful is granted an opportunity to amend the pleading, but in certain instances the court can say, like with A and B, I'm striking or I'm setting aside or I'm dismissing your claim. You can come back once you have a proper claim. Okay, so it depends on the circumstances. Competent orders in exceptions are, of course, upholding the exception, granting an opportunity to amend, dismissal of the claim, striking of the plea or defense, annexure to the particulars of claim, etc., etc. Okay, that is exceptions. You mean that it's a typing error in the particulars of claim? Well, you'll have to amend it. But you can't tell that to the court. The court's not going to ignore you when you say, the court's not going to give you an opportunity to say that you have actually made a typing error. The court's not going to worry about that. That's your problem. If you know, once you've received a notice to defend, a notice of exception or an exception proper, that it was actually only a typing error, then that party should be proactive and should actually move for an amendment before the exception is set down. And say, oh no, sorry, we don't need to argue this, I am at fault, sorry, I'll correct it. That's what should happen. Okay, so we proceed now. Any other questions on exception? Okay, for the moment, you may have some after lunch, and we'll deal with that, it's fine. Just before we break for lunch, we have about 10 minutes. I just quickly want to introduce you to what is called irregular proceedings. So you have exceptions on the one hand. And you have irregular proceedings. Now, Rule 61 deals with irregular proceedings. It says you have 10 days. So here, 10 days. Here, managing judge's directions in terms of the case plan. So the rule 61, we spoke about it briefly yesterday, says that for irregular proceedings, you have 10 days from becoming aware. Whereas in case plans, you will see that, or the rule relating to case plans, you'll see that, in fact, the court says the timing of raising irregular proceedings will be dealt with in the case plan. So there's a bit of an anomaly. You'll be safe to stick to the 10 days and not wait for the case planning conference to come. Irregular proceedings is very specific. So here, irregular proceedings deals with the form or procedure. This one deals with substance of a pleading. So the court will not concern itself in irregular proceedings whether a case has been made out or whatever. It simply is, did you or didn't you comply with the rules of court? That is the only question. Is this step that you've taken in compliance with the rules or not? If it's not, it's an irregular proceeding. So where the rules have not been complied with, the party aggrieved by the non-compliance is entitled to various remedies, and the court is given wide powers to deal with the matter. The court will always take a pragmatic approach that's in the interest of the administration of justice. A party who is prejudiced by an irregular step should not treat it as a nullity, but must apply to set it aside under the provisions of Rule 61 as being irregular. So, prejudice, very important. In order to be able to rely on this, you must be able to allege and show prejudice. Prejudice is not a requirement in the sense that it is probably, with exceptions, implied that a party is prejudiced in having to plead to or answer a claim that is vague and embarrassing or doesn't disclose a cause of action. So prejudice here is really implied in the very raising of an exception. Whereas here, in order to succeed, you must allege and show that you have suffered prejudice as a result of the non-compliance, because not all non-compliances with the rules cause prejudice. Does that make sense? Okay. You cannot just ignore an irregularity. Once you notice it, you must apply for it to be set aside as an irregular proceeding. Otherwise, the court is entitled to accept that step. An irregular step must be one which advances the proceedings one stage nearer completion. So if a party takes a step in the proceedings which is not meant to take the proceedings any further, the main proceedings, then it's not an irregular, it cannot be an irregular step. the rule applies only to irregularities of form and not matters of substance. So you won't raise the issue of locus standi, prescription, and the like, by means of irregular proceedings. Irregular proceedings have found application in urgent applications where no grounds for urgency are stated. Because if you don't, in terms of the rules, state that the matter is urgent and state the grounds upon which the matter is urgent, then it is an irregular proceeding. It has found application for non-compliance with Rule 45.7, which you will recall is the rule relating to the written agreements and agreements in general and the allegations required to be made. Improper service of a summons, an irregular notice of bar, that's in the old dispensation, it's not applicable these days, bar happens ipso facto, and then defective notice of appeal. These are just examples of where you find irregular proceedings. Nature of interlocutory, it's got the nature of an interlocutory application, and both of these must say with particularity the irregularity complained of, and this one must say with particularity the grounds of exception. So you must say why you are complaining. Court can't guess. It's not available to a party who has taken a further step in the cause and thereafter seeks to set aside an irregular or improper step. Doesn't differ much from an exception, because if you don't use it, you lose it. So if there is an irregular proceeding and you nevertheless take a further step in the proceedings, which does not include the filing of a notice of intention to defend, but any other further step, meaning a step that advances the proceedings further to completion, if you take such a step, despite the irregular proceeding, then you are thereby condoning the irregular proceeding and cannot later seek to have it set aside. I've defined for you further step. It's some act which advances the proceedings one stage nearer completion, but does not include a notice of intention to defend. This is a qualifying step. Further steps include, inter alia, the delivery of a declaration under the old rules where you still had simple summons, notice to plead, a plea. Notice to plead has also now fallen away in the new rules. A plea, a replication, notice for security for costs, or request for trial particulars. All right, these are all further examples of a further step. Prejudice requirement. Court has a discretion. An irregular step will not necessarily be set aside. So the court may say, yes, there hasn't been proper service, but here you are, Mr. Defendant, so I'm going to condone this. The matter will proceed because you received proper service, for instance. Or the court may say, yes, well, it is so that the plea was filed while the person was still under bar, but he or she has in the meantime applied for upliftment of the bar, and I'm going to grant that, so I'm not going to set aside the plea. The plea can stand. Court has a discretion. The outweighing objective in irregular proceedings is prejudice. What prejudice is the other party suffering as a result of the non-compliance? If you cannot prove prejudice, or prejudice is minor, the court will be very hesitant to set aside an irregular step. The court will try and find an approach that assists the administration of justice, or seeks to administer justice between the parties and will not punish a party for an irregular step where the opponent has not suffered any significant prejudice. Court is entitled to discretion to be exercised judicially. I'm always surprised when they say this because all discretions must be exercised judicially. On a consideration of the circumstances and what is fair to both sides. The court is entitled to overlook in proper cases any irregularity which does not work substantial prejudice to the other party, and proof of prejudice is a prerequisite to success in a Rule 30 application. Sorry, it's a Rule 61, that's just a typo. Just make note, it was the old Rule 30, it's Rule 61. My tongue wants to type Rule 30 still. It's Rule 61. Okay, that is irregular proceedings in a nutshell. So it's lunch. Let this percolate in your minds, and then we'll take questions after lunch. Thank you. I'll see you after lunch.